you want to? Were you saying that you wanted to share something?
Yeah, just really quick because it's good news. So I cannot disclose who yet because they're still completing a job they're currently doing, but we actually have hired someone to be the director of the Oregon Law Commission. So they'll be starting to help beginning in the middle of March. And when we can announce it, it's very exciting. And it'll be someone who I think will have a lot of good experience in understanding how to get started with this group and others right away. So
Well,
that's all
great.
That's all I can share right now, but I did want to share it because it's been a long journey, but and we wanted to accommodate someone being able to finish their current role, but when we are able to share it, we will. But they'll get right to work with this group once they get started, and I'm really excited to be able to share that with y'all when I can.
Well, great. We're happy for you, Sandy. That's one less hat that you'll have to be wearing, and we look forward to finding out who's going to be our new director. Welcome, everyone. Happy Valentine's Day, happy Oregon Day, and happy anything else that folks are celebrating or marking today. I'm glad you could all join us.
12 Weddings in Marion County Day.
Yes, I wanted to call out Justice Kidd. Justice Kidd has started a wonderful trend throughout our state. At his Justice Court, they have for several years now, Justice Kidd.
This is our second official one, but before that, we unofficially did it.
Why don't you tell the group what your court's doing today?
Yeah, well, so in order to both recognize the equal dignity of every marriage and also just to have a whole bunch of fun, we are canceling court today and we're just doing marriages all day. So it's an event that's geared towards people of modest means to give them really a nice wedding, right, with cupcakes and flowers and music. But it's really open to everybody, and it's just a boat ton of fun.
And it may be the inspiration for similar events that are happening today.
It's true. Yeah, it's spreading. So Multnomah and Circuit Court, Clackamas County Clerk are both having similar situations. Next year, Beaverton and Tigard Municipal Courts are joining us. So we're really just starting, hopefully, a statewide movement to recognize the dignity of marriage and invite people into that institution who maybe haven't always felt welcome there.
Plus, that makes Kidd Justice the love judge.
I am the Marion judge from Marion County.
A Marion judge. I had the chance, along with my clerk and law school extern, to go and see Justice Kidd's Halloween wedding day. And his court just does an amazing job welcoming people in, meeting with the couples before the ceremony, getting to know them a little bit, and then personalizing the services for them. So if you have a chance to see his court on one of these special days, it's really, really worth going to. And if your court is thinking about having one of these special days, or if you want to put the little, word in someone's ear that it might be a good thing for your local court to do, I would recommend seeing how they're doing it in Marion County. So we won't keep you from I imagine you have a 1 o'clock wedding.
I do.
So we'll try and keep going, and we will get you out for that. We have as our first agenda item, substantive agenda item, we have a check-in in our small groups. That's jurisdiction with Jim Nass. And Jim emailed the group, sent the email about his work group to us right before our last meeting in January. So people have his email about that, and it has the work group's recommendations for revising both the jurisdiction statute and then relatedly making changes regarding the animal abuse statutes, because those gave jurisdiction to local courts, but some of those crimes are felonies, and this would clarify that those felonies don't come to the local courts. Jim, it seems like we have the material from you in your email. And I wanted to, ask anyone if you have any feedback, please provide that to Jim. And then Jim, maybe the next step would be to work with legislative counsel. Victor's here today just because unavailable because of the legislative session. I would think after the legislative session is done, maybe you and Victor and Jessica could get together on the proposed wording of the revised section 1 and any changes. Does that sound like a plan? And in the meantime, anyone who had particular feedback on Jim's group's changes could relay them to Jim? Oh, I think you have the same microphone issues that I've been having, Jim.
Can you hear me now? Okay.
Yeah.
I think it would be great if we could get any feedback, barring any additional feedback and barring any other recommended changes that our work group would like to make. I think the idea of working with legislative council makes sense.
And Victor, I imagine after the session is much better, and maybe you and Jim and Jessica can find a time after the session to turn to the wording of these provisions.
Absolutely, Justice Duncan. I'll follow up with Jessica to let her know that we should be in touch with Jim to move forward with this after session ends.
Great, thank you. And then Justice Kidd, you and Heather, who I don't see on the call at this moment, have been talking about default judgments. I don't know if you have any update, but just wanted to touch base in case you did.
Yes, Heather and I and Jim met. We came up with, I think, a nice, it was a really productive meeting. We came up with something that the three of us like, and then I promptly fell down and did not get it to my fellow judges. So that the delay is on me, but the subcommittee at least has some common ground.
That's great, and I'll just keep it as one of our check-in items at the beginning, and you guys can let us know how things are going. Great. And that brings us to our review of the sections of the draft that we're working on. We're on section 16. Last time we were talking about appeals from guilty and no contest pleas, and a question arose about how are these, if you've entered a guilty plea and you want to challenge your sentence, how do those appeals work? What is the circuit court supposed to do when you're only challenging your sentence? And in looking at the materials that went out for this meeting, the materials don't reflect that we actually reached a decision on this issue. And my memory didn't fully serve me as far as whether we had done that. But what we're talking about is section 16 and appeals from guilty pleas and no contest pleas. And Jimmy has a discussion of this issue in his memo. And the proposal there, Jimmy, was that if there's a appeal from a guilty plea or no contest, and the appellant is challenging the sentence, what would happen there, rather than being any sort of a review of the legality of the sentence, which is what happens when you go to the Court of Appeals, this would be just a full resentencing, because the circuit court sitting as the appellate court for the local sentence isn't really in a position to do a review for errors of law. Is that correct? I also see Paul Smith nodding on this one, and I know the two of you have been talking about these types of appeals. Did anyone have any thoughts about that process? It would just be, if you are appealing your sentence, you go to the circuit court, there's not a review of your guilty plea. There is a new sentencing proceeding in the circuit court. I see Justice Kidd.
Just a question, actually. So in the case that the circuit court did a resentencing, does the judgment get remanded down to the justice court for entry of judgment and collection of the fine, or does it stay at circuit court?
Thoughts on that? Thoughts on how that's currently working?
It's different
Justice,
in every place right now.
Justice Duncan, I think under current law, the circuit court has the option of either imposing sentence or remanding. My understanding is that some circuit courts do remand for resentencing with directions, but that probably most circuit courts go ahead and just enter judgment. Now, when I say that, that's based upon appeals of the conviction. I don't know that there's any history of appeals just from the sentence. And that is consistent with what appellate courts do. Also on the issue that Paul and Jimmy looked at about what is the practice of the appellate courts, I think under ORS 138-257, if the Court of Appeals modifies or reverses any part of the sentence, it must remand all of the sentencing. And then under, I think it's under subsection 3 of the same statute, it makes clear that the trial court then has full authority to resentence the defendant. And certainly the point that Paul and Jimmy make, that given that the on appeal from either a justice or municipal court, the circuit court scope of review is de novo, that all makes sense, that the that the defendant should be totally at least that the circuit court would have the authority to totally resentence the person. Now, on the issue that Judge Kidd raised, I think this work group ought to take a look at whether the default practice should be a remand to the justice and municipal courts, because as Judge Kidd alluded to, the revenue often or perhaps always follows which court imposes the final sentence. I took some time a couple months ago and went down to Marion County Circuit Court, and I think they gave me 2 years worth of appeals from justice and municipal courts. And I would say probably in about 2/3 of the cases, the defendant failed to appear on appeal. The circuit court then found the person guilty and imposed the same fine that the lower court had. But the interesting result is that my understanding is that Marion County then gets the revenue from the fine rather than the revenue flowing through either the municipal or justice court. And personally, I think a better practice would be to have the revenue flow through the justice or municipal court. Certainly in the cases I looked at, in most of the cases, the circuit court didn't expend much in the way of resources handling those cases. But remanding for imposition of final sentence would be consistent with what appellate courts do generally.
So Jim, are you saying for the guilty pleas, if they want to challenge the sentence, it would come up to the circuit court and the circuit court would impose a sentence but remand?
It would do this, for instance, if the defendant appealed the judgment of the conviction and sentence solely for the purpose of challenging the determination of guilt, if the circuit court on de novo review affirmed the finding of guilt, what I think it should do is simply affirm the justice or municipal court's judgment rather than entering a whole new judgment imposing a fine. And
So I think, yeah, we'll have to keep clear our appeals. So there's the appeal if you're challenging your plea, if there is such an appeal. And then there's the appeal where you've pled and you're only challenging the sentence.
but well, my thoughts are if the defendant is appealing only the sentence, likewise, if the circuit court on de novo review affirms that sentence, I think that's what you do. Rather than the circuit court entering a whole new judgment imposing a fine, it should simply affirm the justice or municipal court's judgment. If the circuit court reverses or modifies the sentence, then I think in most instances, at least, that the circuit court should remand the case to the justice or municipal courts to with directions, and then the municipal or justice court would reimpose the new judgment consistent with what the circuit court ruled.
Okay. I saw hands up, I see on my screen, Jimmy and then Judge Cross. Jimmy?
Sure. So I think I disagree with that. And I think the reason why is because unless the circuit court enters a judgment at the end of the day, there's no way to get to the Court of Appeals. And I think there needs to be a path from a justice court that's not a court of record, ultimately to the Court of Appeals. And currently the only path is you appeal to the circuit court, get a de novo, whether it's a de novo trial or resentencing, get a judgment from the circuit court, and then appeal from that judgment to the Court of Appeals. If the circuit court then doesn't enter a judgment, then you can never get to the Court of Appeals. You're just stuck with that one level of appeal. And I don't think that's what we're intending to do. So in my mind, the circuit court should always be the one to enter a judgment at the end of the day. Now, that could have an effect on certain financial things that could be complicated, and maybe we need more stuff to address that. But as things stand now, there's just no other way to get from a justice court that's not a court of record to the Court of Appeals other than the circuit court entering a judgment.
What I'm arguing, I would not argue with you. You need to have a judgment entered by the circuit court, but that judgment, instead of itself imposing the sentence, the judgment could be reversed and remanded with instructions to do X, Y, Z. And then the appeal could be taken from that judgment. Just the same way when the Court of Appeals renders its decision, that decision is subject to review. And so the parties would have the opportunity to seek further review of it. But if no one does seek review of it, then once the time period for doing so passes, the jurisdiction would revert to the justice or municipal court to enter judgment consistent with the judgment of the circuit court.
I think we could do it that way, although we would have to rewrite, I think, section some of the later sections to make clear that circuit court, that you could appeal to the Court of Appeals from such a judgment of the circuit court, which is not currently provided for in any of the appeal statutes.
Yes.
Jim, is the procedure that you recommend because of the revenue concerns? Because maybe we can pull those apart in the interest of saying you go from the local court to the circuit court to the Court of Appeals, and the case keeps going as opposed to bouncing back and forth. So I'm wondering, is it the revenue concern? And maybe if that's the concern, it's something we can address separately than just like how the case proceeds.
Revenue is part of it. The other one is just the principle that the justice or municipal court is the original trial court, and that the role of the circuit court is to be an appellate court. The scope of its review may be different, that is de novo, but that does not mean that the procedure should be different than any other appeal in other courts would be. There's also, and I don't know if this is a valid concern or not, but I have always wondered, how do justice and municipal courts track the judgments that they enter when the case goes up on appeal and then the circuit court enters its own judgment? Do we end up with two judgments against the defendant, or is there some process that justice and municipal courts follow to take those judgments off the record so that you don't end up with two different judgments against the defendant for the same
Or we go to the hands up. I'm wondering if anyone has that answer to Jim's question. Yeah, Jimmy?
So I think this is fuzzy under the current statutes. The guidance I found was a 1977 Court of Appeals case called State versus Lyman. That's 30 ORAP 955. There it says, once an appeal has been taken from the lower court to the circuit court, the lower court judgment is considered as not having occurred, and the circuit court judgment is dispositive of all the issues of law and fact. Now, I don't think that could be quite right, because I think the judgment doesn't go away at the time of the appeal, given that there are stay provisions in the law, but I think there seems to be some kind of automatic vacatur principle that's at least assumed by the Court of Appeals under current law. I think this is something that could stand to be more clearly addressed.
As a practical matter, what we do in my court is we consider it a stay of my existing judgment until there's another judgment, and then we vacate our judgment, is what we do. But that's just what we created.
Yeah, I actually don't stay the judgment in my court, but if and 7 years I've been here, first of all, there are hardly any. There haven't been very many violation appeals, but none of the violation convictions were overturned by the circuit court of those that were appealed. But if it had been, the intent then would be, of course, to refund anything that was paid, be refunded to the defendant immediately.
My concern is actually more with those cases where the circuit court enters a new judgment, that the circuit court also finds the defendant guilty and enters the same or different fine. What then becomes of the judgment that your court entered?
We remove our communication to DMV. We pull that back, but our record still reflects that the person is guilty, but we just scan in the circuit court file on top of it. I agree it's messy. I think we should address it. For what it's worth, this one guy, I agree with Jim that his analysis is really good.
I would think that if there's a judgment of guilt in the justice court or municipal court, and if the circuit court renders a different verdict on a de novo appeal, it would be our obligation to make sure that our conviction got vacated off of the person's record, and would be just so it would be if the circuit court order, again, that hasn't happened to me, but if the circuit order did not accomplish that, then I believe we would need to send into DMV a vacate of the conviction to reflect what the circuit court had ruled. I think that obligation would be upon us under existing law. But it might be helpful to spell that out if folks think that's the right way to go about it.
So what at least I'm hearing a agreement on is we need to be clear about when the case goes up and you get a judgment from the circuit court, what happens to the local court judgment, that's not entirely clear, and we should make that clear. Yes, Melissa.
I was just wondering if maybe it could be something in the circuit court judgment that says the lower court's judgment is hereby vacated. I think that might be more streamlined than waiting to see what the lower courts do.
But somebody has to make sure that gets communicated to DMV. And if the circuit court's going to do that, well, that's fine.
But be clear about the process. And I like the idea. I mean, when the appellate courts issue opinions, it will say in the opinion itself, and then later in the appellate judgment, like the Court of Appeals decision is affirmed and the whatever, or the trial court decision is reversed in the cases, and it describes what your disposition is. So that would be something we would prescribe in the in a provision about the contents of the circuit court judgment. All right. Thoughts on, we've heard Jim's thoughts and Jimmy's thoughts on the nature of whether these cases should be going back after you have a resentencing, or not a resentencing, the appeal where there is a new sentence imposed. Anyone else want to weigh in on that issue? Judge Cross, your hand is up.
Yeah, I a couple of things. On that particular question, and there was a couple of things I'd raised my hand about, but there's on that particular issue, I think it should be remanded because I do think the revenue issue is important. And again, depending on what we do with the filing fee issue, but I mean the notion being that the filing fee is what compensates the circuit court for their time and what they spend and what they do, as set by statute. And but the whatever the fine ultimately winds up being, if the municipal or justice court is affirmed, or whether there's a change to the sentencing, to the judgment by the circuit court, that it should be sent back to the municipal or justice court, then to reflect that, if there was a change, or to simply maintain it if there was not. And that's where the defendant's financial obligation would rest, is with that court, the trial court. That's my take on it, and I think that's what I see nothing in the current statutes to contemplate anything to the contrary. Now, one thing with Jimmy Brewer's there was context for some of his work was that there's no appeal, there's no record in the trial court, in the municipal or justice court, that's not a court of record, and with regard to judgment, with regard to sentencing. And I don't agree with that. I mean, there's no record of the proceeding and the whole thing in terms of everything that's said, but the written judgment is there. There's a record of what the written judgment is, and the obligation is on the trial court judge to have filled out that judgment in an appropriate fashion. And if they fail to do so, that can be certainly part of the basis for the appeal, and potentially for a reversal of the finding. But in terms of ruling on whether it's the current language, in terms of whether it's a legally permissible order, that's what is written is what exists for that purpose. I don't see how. I don't agree with the statement that there's no record of what the trial court did in that regard. The written judgment is the record for that purpose, in terms of whether it's a legal sentence or not. And that really should be there. The origin of that was a contemplation that the circuit court review of that issue would be limited to that topic, and I don't see any real basis to change that. So,
Paul Smith.
there's one thing I wanted to say, but I've now forgotten, so I'll be quiet.
See Paul Smith, and then Jimmy Brewer's hands up.
Well, just to that last point by Justice Cross, Judge Cross, I'm sorry. So I mean, the way the draft is worded now is when there's an appeal following let's say a guilty plea of just the sentence, the circuit court is reviewing whether the lower court failed to comply with the requirements of law in imposing the sentence. And I would agree that there are some things that will appear on the face of the record whether the sentence fails to comply with the requirements of law. I think my concern, and this is why I kind of I think Jimmy and I are in agreement that the appeal of the sentence in the circuit court should be de novo, is you can imagine a whole host of errors potentially that aren't obvious from the face of the judgment that might require some type of factual development. And I think that's kind of hard to tease out, which of those require factual development and which don't. And that's why, since there are some that clearly would require factual development, I guess I thought it made most sense to just have the circuit court reviewing that sentence de novo in that circumstance and conducting a whole new sentencing hearing where it can impose.
I don't know about you guys, but I've lost Paul.
I lost Paul.
But what he brought up strikes my head. I was thinking about this topic from the viewpoint of violation cases, because that's what because the DA's office in my county simply doesn't file misdemeanors in my court. They could, they just choose not to. So that's fine. And I think there's really probably a distinction here to be made between violation cases and misdemeanor cases in this regard. And I think really that probably Paul and Jimmy's viewpoints were coming more from the misdemeanor side of the equation. And I wasn't thinking that way when I read them, when I was going through the materials, because I'm set in my ways in terms of what I get in front of me. So I think that maybe a distinction between violations and misdemeanors might be appropriate in that regard. But I don't know how other folks feel about that.
I know there's a challenge that Jim has identified with identifying the differences between violations and misdemeanors, and that may present problems here for trying to say if you are challenging your sentence in a violation, there's this procedure, but in a misdemeanor, a different procedure. Judge Brisbane. I see Judge Brisbane's hand.
Thank you. Well, because violations follow criminal procedures throughout the statutes, I think it would be best if we could come up with one set of rules for violations and misdemeanors. We are not a court of record in the fact that we don't record the proceedings, but we do have a written record, and parties can ask for findings of fact to develop the record in the lower court, which would go to circuit court. But also when we get as far as the fine, where the fine remains, once we get to the municipal court statutes, there's a specific statute that states that once the circuit court makes the determination on the fine amount, circuit court will collect the fine within 10 days and send it back to the city. I think that probably needs to be changed. For one thing, it should be the lower court's obligation to collect the fine and pursue that rather than circuit court. But there's no way it's practical to require circuit court to do that in 10 days in any way, because most people are on payment plans for months or years. Not that many people walk in and pay even $115 in a lump sum.
Can we talk about the restitution issue, which is Paul and Jimmy have their email, and the issue with restitution is that if you may have your original sentence judgment, and then restitution could be imposed later in a separate judgment. And so what if a party wants to appeal the restitution? And the concern was, well, sometimes the restitution might have been a factor in determining how much you had to, for example, pay in a fine. If the party knew that, if the local court knew that you were going to be on the hook for a significant amount of restitution, it might not impose as much of a fine. If you appeal the restitution and the restitution goes away for some reason, and then you might have the benefit of an assumption that there would be restitution and you might have a lower fine. So I think I'll turn it over to Paul and Jimmy to talk about the proposal for this scenario.
I can talk, or you can, Paul.
Go ahead,
I'll
Jim.
go ahead. So I think it's sort of two aspects to this. One is we initially went into it with the idea of mirroring what the law is in the Court of Appeals. And I think in some circumstances that's clear and you would get a whole resentencing. In other circumstances, maybe it's not as clear, or at least less clear for me than it is to Paul. But I don't think that really matters at the end of the day if our goal really is to make sort of a public policy decision that makes sense. And I think for the reasons that Justice Duncan outlined, I think it makes sense most of the time to, and I think we need a uniform rule, but I think there are certainly going to be some circumstances where knowing what the restitution amount will be or a different ruling on restitution could have a different impact on the rest of the sentence. And just giving the circuit court all the tools it needs to make, complete flexibility to adjust parts of the sentence to account for a different restitution ruling or vice versa. Well, not really vice versa because restitution is kind of mandatory, but giving the circuit court all the tools it needs, I think is probably the best approach and avoid some injustices that might result if that's not the case. And I think Paul in his email proposed some language like the circuit court shall conduct a de novo sentencing hearing with authority to impose any lawful sentence. I like that language a lot. I think it's very clear about what should happen. So I think maybe just adding that in another provision or another line would solve the problem.
Paul, anything to add before we open it up for questions and comments?
No, I think that accurately summarizes it. Other than ultimately, this gets back to the discussion that we've just been having, for the last 20 minutes, which is what do we think the sentencing an appeal from a sentence should look like? And so I think our assumption going into this was that any appeal from a sentence would be de novo in the circuit court, and therefore, of course, if it's just a restitution appeal, you need to have the whole sentence before the circuit court in that circumstance.
Just can I see your hand?
Yeah, I wonder if just tweaking that slightly, and so it should be that the circuit court would order that the justice court impose a sentence that is consistent with their order, right? So they could say, actually, I find the fine is $225. Justice court, you shall impose a fine of $225, because that is more, and restitution of whatever. Because I agree with Jim that it more tracks what appellate courts do, and also for smaller courts, the revenue stuff matters a lot. I think we have only big court judges here, or relatively big court judges, but for small counties, especially if we start to change the appellate fee structure, that we could have some really unintended consequences if we start monkeying with the way the revenue works for the small counties.
So it sounds like along the lines of what Judge Brisbane was saying, this discussion about whether what we're doing is saying you get a judgment from the circuit court essentially that supersedes any, like one path would be to say you get a judgment from the circuit court, that's your judgment, and there's no need to remand for entry of a new judgment. That's one path. Another path is for the circuit court basically to be saying, here's what you should impose. Like the circuit court's judgment is like directions to the local court, and it would go back down. So it seems like those are two different approaches. The need for the second one are the reasons that Jim has articulated, but one of those is revenue, which may be informed by the statutes that Judge Brisbane is pointing out. If there's already provisions that say when the circuit court acting as the appellate court does whatever it does in its judgment, here's how the allocation of the fines, separate from who collects them, but here's how the money is allocated. Though the existence of those statutes, I think, should inform this choice between the two paths.
But it only says that for city courts. It does not say that for justice courts, which is a whole. So we should make it the same, obviously.
Okay. So that seems like a pretty fundamental decision that we will have to make, which is like, are you just coming up here so that we can send you back down so you can get a new judgment, or are you coming up here and you're getting like a replacement judgment that can go forward? And if the money is handled by the other statutes, then maybe we don't need to send it back down. Tony and Jimmy, I see your hands in that order.
Thanks, Justice. One question I had is this discussion's going on, and this is mostly out of my ken. I don't really know how the money gets handled or any of that, but do circuit courts have authority to tell justice courts what to do, like a remand? And the other layer of, as has been raised, do circuit courts have authority to tell municipal courts what to do with their original judgment? I don't know. I've not heard of that. When I'm observing and making my comments, I'm trying to look at it from the point of view of how it would affect defendants. So going back to the issue of just the de novo appeal, I mean, I think everything should be a de novo. I would think a circuit court judge should have some latitude to look at all the issues, and the parties are going to be responsible for raising those. And going to that restitution issue, the restitution is part of the judgment. So I think if a defendant appeals from a judgment that includes a restitution figure, they are, they take a risk that on a de novo appeal, the circuit court will make a lot of changes to it, So that's kind of where I would think the defendants should be expected once they make an appeal. Defense lawyers would advise them, you send it to circuit court on an appeal, everything's up for review. So that's just my 2 cents.
Thank you. And then I see Paul and Jimmy. I don't know which of you popped up first.
Sure, I can. So I think we sort of have two models. One where the circuit court enters something new called like a remand judgment or something, and you appeal from that to the Court of Appeals. And the other thing would just be the circuit court enters like a normal criminal judgment. I think if the only advantage of doing the former over the latter is this fines issue, there might be a more elegant solution of just adding a new statute that says when in these types of cases, when the circuit court collects the fines, it shall be remitted to the justice court, or some language along those lines. I think doing it the other way is doable. It's just creates some difficulties with refining the statutes about how you get from there to the Court of Appeals. May also open an issue with probation. So if the circuit court is resentencing in misdemeanor cases, a lot of those sentences are going to include probation. And it seems a little odd that the circuit court would be imposing probation conditions or a particular package and then remanding it down to the justice court to enforce that, when that may not have been this package that the justice court would have imposed, and where the justice court may not entirely understand, how that's meant to work or what the circuit court had in mind. It seems to me cleaner if the circuit court enters just an ordinary criminal judgment for certain applications, but others may have better handle on the practicalities of these things.
Paul and then Judge Frost.
I had 2 comments. One, in response to Tony's question, it looks like ORS 157065, at least in the context of a circuit court reviewing a justice court, gives the circuit court the power to remit the cause to the lower court in accordance with the decision of the circuit court. I don't know if there's a similar statute that gives that same authority with respect to appeals from municipal courts, not a court of record. But so that's what I found there. And the other thing with respect to, do we need a circuit court judgment so that there can then be an appeal to the Court of Appeals? This could be an area that I'm failing to understand. I always thought I didn't know that the Court of Appeals had unfettered jurisdiction to review basically a second level of appeal then, because this is someone who would have been convicted in a municipal or justice court, not of record, had their right of first appeal to the circuit court. And I'd always thought that the Court of Appeals then didn't have authority to review what that circuit court had done via direct appeal. There may be other avenues for higher appellate review there. And so I guess, and that may be something we need to sort out, or it could be my mistake on that. But if the only point of having the circuit court judgment were to preserve the right to further appellate review, and there isn't that right, then I think the idea of remanding back, the circuit court remanding to the municipal court or the justice court makes a lot of sense in that circumstance.
Any thoughts on that? We have in the current law provision that says when you have your appeal to the circuit court, then you can go to the Court of Appeals as if the case had originated there. I don't think that's that may not be for pleas, but I think it is interesting in this area that you can you essentially get more review if you're coming out of the local court, because you go from the local court to the circuit court, and then once you're in the circuit court, you're in the same boat as if you'd started there. So you get another, there's this additional layer of review. My understanding was that was because that first layer was not a court of record, but I may not be if anyone has any other thoughts on that or information about that. I think it's unusual, but I think that's because the law is allowing folks to come from the local court to the court of record, and then from there they're kind of in the same boat. So you get more review if you look at it that way. So I think you can go from the circuit court to the Court of Appeals under current law.
My speculation, Justice, is that's based upon the de novo notion that the de novo in the circuit court therefore creates an appealable order.
Yeah.
To the Court of Appeals.
I think so.
But again, that's my speculation. I believe that's the case. Yeah. I wanted to, if I could, I would touch on the collections issue, but if you want to continue the discussion here before I go back and do that.
That's fine.
So, because I think it was Jimmy Brewer had brought up, they just have the circuit court collect the judgment and then send what they collect to the local court, which sounds good if you're not thinking about the way it actually functions, because for judgments from the lower courts, they're good for 20 years. The circuit courts is not going to really go about collecting these things. They just tend to send things off if they don't get paid immediately. They send them off to the Department of Revenue. Whatever goes to the Department of Revenue is entirely kept by the Department of Revenue, and there would be nothing to send to the local court. So it's just as a practical matter in terms of how it functions, that wouldn't work for the circuit court to do it. Plus, the circuit court's not really interested in doing that, and under those cases, in my experience, I'm taking on that obligation. So, I just don't think it's a practical matter where it would be very effective to do it that way. It makes sense on paper. It just wouldn't work. Because they send stuff off to DOR and RB.
In our last few minutes, one of the things that we have on our list of things to talk about is probation judgments, and I'd love to get a sense from the people who are in the local courts how often this comes up, like how many probation cases end up going. What's your experience with them going to the circuit court, who takes it from there? Do they come back to you? How does it work as a practical? Anyone?
Just to clarify, are we talking about there's a probation in the lower court and either a show cause is issued or a revocation, and then the person seeks to appeal? I think
Yeah.
that's happened once in our court, once. And my memory is totally failing me at this moment, but I cannot remember what happened to that case. I know it was a big deal at the time, but I cannot remember what happened. I can
And-
follow up though. I can
Okay.
figure out what happened.
And just anyone's thoughts, maybe people can keep this in mind for next time. Like, there would obviously be challenges if a party is saying, I shouldn't have been found in violation of my probation. What is the circuit court supposed to do with that type of a challenge? Because they're not reviewing it basically to see whether what the lower court, they don't have the record, there's no record. So how do they handle a claim that a probation violation was found where it shouldn't have been, or even if a violation was found, revocation was inappropriate, when the circuit court's really not going to have a history with the case, but they have, presumably, they have some role in reviewing these decisions. How is that going to work as a practical matter? So that if people will give some thought to the probation issue, that would be helpful. And then we also, I think in the last 5 minutes or so, we can talk about conditional pleas. So conditional pleas are provided for circuit courts right now. So if, for example, you have a criminal case with a motion to suppress, and the motion to suppress is going to be dispositive, the parties can go in, have a hearing on the motion to suppress. If the defendant loses, the defendant can say, fine, this evidence, in light of the fact that my motion to suppress was denied, this evidence is going to come in, I'm going to go ahead and enter a conditional guilty plea. So then we don't have to go forward with a trial, and the ruling, the defendant can enter a conditional plea with the agreement of the state and specifically reserve the right to challenge that suppression ruling. And then that comes to the Court of Appeals. There's no current provision for conditional guilty pleas that I'm aware of in the local courts. I wonder what people think about whether one is necessary, because you can litigate your motion to suppress in the local court, and then you can go to trial, and then get a trial de novo in the circuit court. So I'm interested in whether this conditional guilty plea should be mirrored in the local court. There could be some advantages, but I don't know. Melissa, do you see these? I think people just do a stipulated facts trial, and then they go to the circuit court and they do another stipulated facts trial.
I don't see them all too off. I don't think I see conditional pleas at all. I think we've had a couple of stip facts trials. I could see this most often happening in like a DUI case, at least for municipal courts. I would say it's possible if we do allow them that we may see an increase in conditional pleas being utilized, which is not necessarily a bad thing, especially if we're going to need to do trial all over again. If we go to a trial, it actually, I think, would minimize resources on the front end, because you would only have to you'd have the plea and then you go do a trial, assuming there's a trial, in the higher court. So I could actually see it being of some benefit in the future, in the long run, actually.
Okay. And then we would have to figure out what the appeal would look like if we do have conditional pleas. But if they could be efficient, then maybe we should keep pursuing that. We are at 12:57. And I want to make sure that Justice Kidd gets to his next wedding ceremony. So for our next meeting, let's flag that we're going to talk about probation judgments. If people want to keep thinking about this issue of what the circuit court is doing and whether they're just remanding with directions or not, keep thinking about that. If people want to look at the fee provisions to see if that takes care of concerns about revenue, please look at that. And we'll pick up with probation judgments, conditional pleas, and then we'll talk about states appeals. Jimmy's memo talks about these, and those of you who are working with prosecutors' offices or just thinking about what do you need to be able to appeal and what's your appeal going to look like. One of the bigger picture questions here is like, once the case gets, if let's say you have an interlocutory appeal to the circuit court, should it stay there or should it come back? It's kind of efficiency questions there. So especially for those of you who have who are familiar with states appeals, please give some thought to these issues that Jimmy identifies about what you need to, what appeals you need and how they, and what they should look like. Okay. That's what I have for today. Krista will be sending out the information for our next meeting. If you have any thoughts on these things and you want to share them with the group, you can send them to Krista and she can disseminate them. And that'd be great. That's all I have. Happy Wednesday, Valentine's Day. All right.
Bye, everyone.
Thank you, everyone.